Okay, today we get to talk about arbitration. So arbitration was invented a long time ago as a separate thing that we can use instead of traditional litigation in the court systems, because the court systems were getting too expensive for people and they needed an alternative to the court systems, so they went with arbitration. Unfortunately, in our experience, arbitration has become very expensive. It's as expensive oftentimes or even more expensive than the court systems, and there's a bunch of problems. So one problem is that you're bound by the terms that the arbiter gives you. So the arbiter functions as a judge, but they don't have to be a judge, and they're not held to appeals. They're not appealable with their decisions. So with a normal judge, if they screwed up the law, you can appeal it, and then it might get overturned if they made the wrong decision legally. Regardless of the merits of the claim, if they get the law wrong, you can appeal it. With an arbiter, the whole way that arbitration is built is so that you can't appeal it to try to save people money. But the fact that arbiters are not necessarily people with Juris Doctorates, JDs, lawyers, judges that are appealable, sometimes they just get it wrong. And if they get it wrong, you're out of luck. So why does it cost as much as traditional litigation? Because generally you have to hire a lawyer on both sides to represent you, and you have a full-on arbitration hearing, which might not have all of the bells and whistles of a jury and things, but it's effectively, in terms of attorney costs, just about the same oftentimes. We do have some success with people using mediation instead of arbitration, so totally recommend that. But in general, we recommend against including arbitration clauses in your contracts because they're not appealable, basically, even if they get it wrong. And they're just as expensive or more, usually, in our experience. And the arbiter judges, putting in quotes, are not as good. So even if you go to small claims court with a case, if you can fit it in there, then it's still appealable de novo as if it's a totally new case in a court hearing. So that's a little bit about commercial litigation. I'm Jonathan Sparks with Sparks Law. Smart business decisions start with Sparks.